welcome to Verdictum. I am Ananya Singh and you're watching today's legal news, where we take you through the latest legal developments across the country. Let's take a look at the headlines. Supreme Court gives nod to Shimla Development Plan 2041, overturns NGT stay. Delhi High Court dismisses Habeas Corpus plea for detained Bangladeshi national. Karnataka High Court strikes down 100% reservation for women in military nursing services. When special officer is appointed, elected directors automatically lose their posts, rules Karnataka High Court. Now the headlines in detail. The Supreme Court has granted approval to the Shimla Development Plan 2041, making a pivotal mark for the developmental initiatives in the capital city of Himachal Pradesh. A bench comprising Justice B.R. Gavai and Justice Arvind Kumar, while giving green light to the Shimla plan, overturned an order passed by the National Green Tribunal, which stayed the development plan. The legal battle stems from the Himachal Pradesh government's initial approval of the Shimla Development Plan in February 2022. The NGT intervened in May 2022, expressing apprehensions about the haphazard manner in which the development plan was made. In response, the state government approached the Supreme Court, which directed it to address objections and issue a final development plan within 6 weeks. The plan, known as the Vision 2041 Plan, was notified officially in June 2023, and its implementation was restrained by the NGT, citing conflicts with its previous order issued in November 2017. The Apex Court acknowledged the safeguards embedded in the development plan. The court highlighted that its finalization involved extensive consultations with experts in environmental sciences, urban planning, and other related fields, while affirming citizens' rights to challenge provisions believed to be environmentally detrimental. The court emphasized that such challenges should be pursued through proper channels. Importantly, the court cautioned against stalling the development plan, given its adherence and statutory provisions and a rigorous procedural framework. The Delhi High Court, in a significant decision, has rejected a habeas corpus plea seeking the production of a detained Bangladeshi national Azal Chakma, who was apprehended in October 2022 at Delhi's Indira Gandhi National Airport for travelling with a fake passport. A division bench of the High Court, comprising Justice Suresh Kumar Kaith and Justice Manoj Jain, ruled that foreign nationals cannot assert the right to reside or settle in India under Article 19, Clause 1, Subclause E of the Constitution of India. The court also noted that the rights of such foreigners are limited to right and liberty under Article 21. Referring to the Supreme Court's judgment in Hans Muller of Nuremberg versus Superintendent Presidency Jail, Calcutta case, the court highlighted the absolute and unlimited power of the Union government to expel foreigners without constitutional constraints. The case revolves around Azal Chakma travelling on the basis of an Indian passport, which was purportedly obtained by fraudulent means. The court observed that Chakma was unable to provide any explanation regarding his return to India after leaving on a Bangladeshi passport. The court also took note of the previous applications filed by Chakma for an Indian visa, where he had identified himself as a Bangladeshi national by birth. Consequently, the bench rejected the contention that Chakma cannot be deported unless his Indian citizenship is terminated, and held that there was no basis for such contention, as Chakma never genuinely acquired such citizenship. In a landmark ruling, the High Court of Karnataka has declared unconstitutional the colonial-era provision mandating 100% reservation for women in the military cadre of nursing officers. The court struck down Section 6 of the Indian Military Nursing Services Ordinance of 1943, specifically the expression "if woman" found in the said ordinance. The origin of this provision can be traced back to the exigencies of World War II, when the British Crown, governing India at the time, introduced the 1943 Ordinance to address the demand for nursing officers. This provision was challenged in 2011 by the Karnataka Nurses Association and other individuals. The plea was rooted in the denial of opportunities to two male petitioners to participate in the 2010 recruitment of nursing officers, leading them to seek redress from the High Court. The court noted that the exclusive reservation of 100% for women violated the constitutional rights guaranteed under Articles 14, 16 Clause 2 and 21. The court also observed that while the 1943 ordinance was adapted under the Adaptation of Laws Order of 1950 by the President of India post-independence, it cannot be equated with laws enacted by the Indian Parliament under Article 33 of the Constitution of India. Notably, the High Court clarified that appointments made under the 1943 ordinance throughout the decades are deemed valid. Emphasizing on the fundamental principle of reservation, the court said that reservation policy should be used to accommodate and include and not to exclude. It asserted that when such accommodation, termed as reservation, becomes 100% and exclusive without any justifiable grounds, it deviates from its constitutional purpose and amounts to exclusion, which has not been envisaged by the Constitution. In a recent verdict, the Karnataka High Court has affirmed that elections must be conducted for all director positions, including those who have not resigned, when faced with vacancies that compromise the required quorum. A bench of Justice C.M. Punancha was addressing the question whether upon the registration of a few members of the board of a society, elections are required to be held to the post of all directors, including the post of directors who have not rendered their resignations. Answering in affirmative, the court disposed of a batch of petitions filed by the elected directors of the SVS Sehkar Sangh Niyamita, Hala Ganahali Primary Agricultural Credit Cooperative Society and the Primary Agricultural Credit Cooperative Society, Khuduvali. The petitions were brought before the High Court as some directors had resigned, leaving the boards without the necessary quorum. Consequently, special officers were appointed by the Registrar of Societies to oversee the societies. Directors who did not resign approached the High Court and contested the move, asserting that as their tenure had not concluded, they should be permitted to continue. The High Court, referring to Section 31, subsection 1 and 3 of the Karnataka Cooperative Societies Act, noted that the provision allows the registrar to appoint a special officer, notwithstanding any clauses in the Act, rules or bylaws. As per Section 31, subsection 3, upon the issuance of such an order, elected directors automatically vacate their positions and the special officer assumes charge of the cooperative society's affairs. The court further emphasized that the exercise of any discretion, as suggested by the petitioners, does not arise in any circumstance. That was all on today's legal news. Thank you and keep watching Verdictum and subscribe to our channel and download the Verdictum app on iOS and Android to keep yourself updated with authentic legal news.